I'm going to go through the preliminary announcements today and run through some procedural things at the beginning. I'm having trouble with my laptop, which is the pictures I show the board. So after I'm through with the preliminary part, we're going to take a brief recess and hopefully get this thing up and running. And we'll get back to the normal business. But we do need to get underway today. The procedure will be to introduce the case record as the Codes Administration has it. On the wall here and the projectors screens there at the rear, it will show any plans, photographs, maps of the properties involved in today's cases, and we'll also present any correspondence we've received from in support or opposition to a case, as well as any correspondence from other government agencies. And at the conclusion of our presentation, the applicant will come first and present their testimony to the board along with any persons in support. And if there's opposition, the board will then hear from those parties opposed to a case. After the opposition has presented their testimony, the applicant will have a period for rebuttal. The board in their rules provides that applicants in cases without opposition have 10 minutes to present their testimony to the board. In cases with opposition, both sides of a case have 15 minutes to present their testimony. So if you have multiple speakers, divide your time accordingly before you come up. All section numbers I refer to today come directly from the Metropolitan Code of Law, Title 17, which was adopted by the Metro Council with an effective date of January 1st, 1998, and applies to the entire jurisdiction of the Metro government. I'll introduce and make a part of the record the zoning code, and I'll dispense from reading individual sections unless the applicant or opposition requests that I read those sections. The zoning code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address this board to please come forward. The microphone stand in front of you, you'll see here a red light around the ring. That mic is hot. The board members will be able to hear you. There's a button on the panel that says speak. When you get done speaking, if you would please, just like I've done there. Should be noted that it's found anyone's presented false or misleading testimony to the board that may have affected this board's decision. Any approval may be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today, and after each case, the board will discuss and vote on that case. The board's vested with the power to act before us under Section 1740, 180 of the Metro Code of Law. The code requires that 4 members of the 7-member board be present to constitute a quorum. The code also requires that you have 4 affirmative votes to grant your application. Today, we have 5 members present. You need 4 of these 5 members to vote in the affirmative to grant your application. In the event that you do not achieve 4 votes today, be it a vote of 3 for and 2 against, or 2 for and 3 against, this case will stay on our agenda for the next 30 days. And it will, the members who participated here today can change their votes. The 2 members who did not participate may review the record and become eligible and can then participate at the next hearing. That would be April the 5th. After that hearing, after 30 days rather, if no members have changed their votes and the other 2 members have not become eligible, your case is deemed denied by operation of law. Any applicant or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within 60 days of today's public hearing. It should be noted that any applicant or aggrieved property owner may request a rehearing within this same 60-day period, but after 60 days, the board's decision is final, and no further action can be taken. If you're an applicant and your case is granted, it is necessary for you to come and pick up the permit for which you've applied. You can do that in the codes office where you filed for your appeal. Should be noted you have 2 years from today's date to obtain your permit. So if you get an approval here today and for some reason you don't obtain the permit within 2 years, you have to come back and seek approval on that case. Mr. Chairman, I submit that all cases were filed in proper order. Applicants were notified by certified mail as required by the zoning code. All affected property owners within 300 feet were mailed via first-class mail, and a legal ad was published in the Tennessean as required by the code. And before I begin with any announcements, the board allows for elected officials to address the board before today's hearing. And if any elected official, Councilman Holloman's here, are there any other elected officials present? Okay. I'll let them address the board before we get started. Councilman.
I'll say that again so that it's clear on your record. I realize now. I didn't realize I controlled the mic. My name is Jason Holloman. I represent District 24 on the Metro Council. My address is 4210 Park Avenue. I'm here to speak on two matters today. One is 2012-27, which I understand the applicant has agreed to defer to meet with the neighbors and try to work with them on something to bring back to you. So I'm in full support of the deferral and the applicant working with the adjoining property owners to try to come up with something that hopefully is more agreeable than what's proposed here today. The other is number 2012-17, which is a front setback variance along Murphy Road at 4005. I have heard from several neighbors as well as the neighborhood association as a whole concerned about this request. The two primary concerns with this request are that there is a continuity of setback along this block face and frankly along the entirety of this street. This is the street that is the primary entrance and exit from West End into the Sylvan Park neighborhood, so it would be significantly visible if this was granted, and it would change the continuity of setback, I believe by at least 5 feet towards the road, and additionally would be taller than the adjacent property. So it would have a significant visual impact. I think beyond that, there is concern that I think is valid concern that there is a fair number of historic homes in this area, including this one. It is contributing to the historic fabric of the neighborhood, and obviously that would be dramatically altered if the front facade were changed. Understand this part of the neighborhood does not have conservation zoning, and so that per se is not a requirement that they not be allowed to build off the front. But in this particular case, the adjacent neighbors that I've heard from and those in the neighborhood feel like it's just a bridge too far to grant setback variances to accommodate that type of addition, particularly when, as it's been pointed out to me, this house does not currently have a rear dormer, so there is room to increase square footage in this house through a rear dormer and potentially through a rear addition altogether. I understand there's a letter from an engineer that says that you would be within the drip line of the tree, but I frankly think that still allows for a pretty sizable buildable footprint off of the rear, or at least through a rear dormer. So for those reasons, I wanted to raise concern about that application and ask that variance not be granted. And depending on the outcome of discussions between the applicant and the adjoining property owners, I may return next time on 2012-27. So with that, unless anyone has any questions, that's all I wanted to say.
Actually, Council, sure. Case 25, it's also listed as your district. Do you have an opinion on that one, or? I happen
to know. I have not been contacted by anyone on that. I happen to know the applicant, and I'm familiar with this lot. It is a very odd lot. If you're on Clearview, Mr. Whitson, you may know this is where there is a house in the middle of a circle, and the street goes around a circle, and so it's a very odd configuration of that street, and this house sits on a pie wedge lot that fronts that circle. So for that reason, it is a very, I don't know the specifics of the request, but I did see it on the agenda, and it strikes me that it's likely needed because those lots are very odd shapes. So.
Okay.
But I guess on the other side, I think if someone had concerns, they would have contacted me, and I have not been contacted by anyone in opposition to that.
Okay. All right. Thank you very much.
Thank you.
And members, in the preliminary announcements, I'll hold off on any discussions on 27. I'll get with the applicants back there to see if a deferral has been worked out. But with that, the board does have, let's see here. The board does have a consent agenda, and before the meeting, a board member comes in and reviews the case record. And if they feel the applicant meets the criteria for the application that's been requested, and they feel that material testimony would not alter the material facts, they recommend the case to the remainder of the board for approval. And Mr. David Harper was nice enough to review for consent agenda today. As I call these cases, ladies and gentlemen, with us, if you are here in opposition to a case and only opposition, please raise your hand. So I can see you. The first case recommended for consent is case 2012-25, Mr. George Clements at 710 Clearview Drive. He's requesting a variance in the rear and street setbacks in R10 to construct 2 additions to the residence. Is there anyone here in opposition to case 25 on Clearview Drive? Mr. Chairman, seeing none, as Councilman Holland alluded to, the exceptional shape of this lot and irregular shape of it necessitates the need for a variance in this case. And Mr. Harper's recommended that case to you all for approval. The next case recommended for consent agenda is case 2012-28, Safe Haven Family Shelter Incorporated, applicant and owner of the property at 1234 3rd Avenue South. They're requesting variances in the street setback and rear setbacks in the RM20 district to construct 3 additions to the existing facility there. Any parties present opposed to case 28? Mr. Chairman, seeing none, the exceptional narrowness, shallowness of this lot necessitates the need for a variance on both the rear and front setbacks. The existing structure is legally non-conforming as to rear setback. The proposed addition is only 24 inches or 2 feet further into that setback. The next case recommended for consent, case 2012-30, Mr. Jeremy Williams at 2108 Riverside Drive, requesting variances in side and rear setbacks in the R10 UZO district to renovate and install a roof on an existing 24 by 24 garage structure. Is anyone here in opposition to case 30? Mr. Chairman, seeing none. This is an existing structure that has a concrete foundation and brick block walls. The applicant is wishing to replace the roof that had been torn off some years back and utilize it on the same footprint. The variance request is only 4 inches on both property lines, so the existing structure sits at 2 foot off the existing lines. And next case recommended for consent, case 2012-31, Edgefield Baptist Church. Applicant and owner of the property is located at 701 Russell Street, requesting a special exception and variance in the impervious surface ratio to construct a new handicap parking lot behind the church with 2 spaces and accompanying sidewalk and canopy to cover the walkway areas. Are there any persons here in opposition to case 31? Present. Mr. Chairman, seeing none, this is in the historic overlay. The Historic Commission has approved the addition, and as part of the process, it comes to you all next. And with this request, Mr. Harper recommends this case for consent.
So moved.
And one other, finally, case 2012-32, Mr. Terry Woodall, the appellant owner located the property at 5200 Indiana Avenue, requesting an item D, which is a addition to a non-conforming use to rebuild the single-family residence in the same location which was destroyed by a fire. Is any persons in opposition present to case 32, Indiana Avenue? Mr. Chairman, seeing none, this would allow the applicant, the home that was on the front of the home. This lot has 2 existing single-family residence structures on them. That's the non-conforming part, that we have 2 single-family houses on this lot. The front house burned to the ground here recently and was demolished, and he came to our office seeking to rebuild that structure in the same place that it was. With those cases recommended for consent by Mr. Harper.
Sorry about that. So moved.
Great. Got a motion? We've got a second?
Second.
Got a motion? Got a second? All in favor? Any opposed? Passes.
If you're here for cases 5, 28, 30, 31, and 32, your cases have been granted. You are free to go. Mr. Chairman, I would ask you if I could just, and the folks here on Channel 3, if I could have about 10 minutes, we'll get this laptop up and running. I'll have something to show you for the rest of the meeting. With that, the board will stand in recess.
Did the deferral come through? Do we know?
I will check on that
Okay.
here at the break and report back to you.
Thank you.
On the front. On the agenda for that meeting. And I don't necessarily need a motion from you all, but if both parties agree, that'll be fine. So for the record, case 27 will be heard on April 5th at our next meeting. So we'll begin now, and we'll call the first case, case 2012-15. Richard Agabar. I'm sorry, I apologize if I butcher your name. Is the owner of the property at 181 Little Green Street. He is requesting variances in parking. I'll have to look at that. I believe the parking variance is being withdrawn. He will comply with the parking code as far as number of spaces, perimeter landscaping, and impervious surface ratio, and driveway width in the IWD UZO districts to construct a new one-story. The applicant's proposing to eliminate one of the bays in this building and make it a single bay repair garage. That bay is important because that is the basis of which we determine the required parking. 2 bays would require 10 spaces. 1 bay would require 6 total. On that, this is referred to the board under section 1720.030, 1724.150, and 1720.060. The applicant has alleged the board would have jurisdiction under section 1740.180B. This case was deferred from the meeting of February the 16th. I'm going to step back and go through the slide pictures to refresh everyone's recollections on this, and then I'll turn it over to you gentlemen to begin.
Did you say this was deferred from a previous hearing?
Yes.
Was I present?
That was my next thing to see. Who may participate in this case? Got that folder.
It's going to be embarrassing if I was here. I don't remember it.
Mr. Harper, you do raise an interesting point, and unfortunately it's an unfortunate point and goes along with our Ides of March theme. I only have 3 members sitting before you that participated in this case. So we have a couple options you could do. One is we defer this case until I get 4 members that heard it the first time. The second option would be to hear this case as a brand new hearing from the beginning with the 5 members present before us.
Why was it deferred?
It was deferred to allow the applicant time to meet with the neighbors and come up with a new site plan. That new site plan is before you today, and the neighbors are here and present that were present at the last hearing.
I would move to hear it again.
Okay, got a motion, got a second. All in favor of hearing it anew? Aye. None opposed. We'll hear it anew.
This case is a brand new case, so all parties here today, references to the last testimony can't be discussed. They have not heard this before. I have 2 members here today that did not hear any testimony before, so this case will be treated as though it's a new hearing. Let me recap for.
And Joey, can I ask, was there opposition?
Yes, sir.
Presented last time?
Yes, sir, and those same folk are here today.
Okay.
So we have all the parties that were present before. Had we not had that, there's no choice but to defer. The subject property is located on the south margin of Little Green Street. This will be just west of Edgar and north of Meredith Avenue.
Hey, Joey, I'm sorry. Actually, there was one other opposition witness, if I remember correctly. Wasn't Mr. Jocelyn here?
Yeah.
It-
Yes, sir. I believe he was here.
Does it, so, I mean,
Yeah, no, I mean, the best thing to do is to push this case to April 5th because I need all the parties present.
I think so. I think he did participate.
participate.
Yeah, okay. So, yeah, I'm sorry. There was a fifth opposition witness. So, actually, I'm going to move we defer this because I do. But anyway, is there a second?
I'll second.
Okay. Got a motion, got a second. All in favor? Aye. Any opposed?
No.
Sorry, gang. We're going to have to defer y'all.
And during this time, the deferral, this case will be heard first on April 5th. I need to be certain that we have the 4 members present, but also this provides both sides to have additional time to sit down and talk. I do recommend you all do that between now and then. See if there's anything further that can come from discussions amongst y'all. That may eliminate some other variances, but again, I apologize to the applicant on this one. You'll have to come back April 5th for that hearing. With that case, case 15 will be deferred to April 5th. Yes, sir. And Mr. Chairman, we'll call the next case this time. Mr. Chairman, for the record, that case was deferred from February 2, the prior case. Next case, we'll call case 2012-17. Ms. Joe Emily Smith is the appellant and owner of the property located at 4005 Murphy Road, requesting a variance in the street setback in RS 7.5. This is to construct a 13 by 32 story addition to the front of the residence. This case was deferred from February 16th. All persons present, according to record, were here. We had all 7 persons that heard the original case, so all of you here are eligible for this case. This case was deferred at the request of the board for the applicant to provide some elevation drawings that were submitted. You have those before you. A copy of which was given to the councilman when he was here. The only elevation I have to show you was one. The side elevation was submitted today, and you have that in front of you, but this was the front elevation. Again, reviewing the photographs from the original hearing, this is the subject property as viewed from the driveway at Murphy, looking into the subject site. The adjoining properties sitting on either left or right-hand sides, and then the proposed addition would come out approximately to this point here, looking at the adjoining properties both left and right. And I'll refer back to the site plan. The proposed setback here is a 12-foot variance requested. The required setback is 47 feet, and that's based on the average of the homes to either side. Murphy Road is a collector street, so in this area, because it's a collector street, we have to take the average of the homes to either side. Where Murphy, not a collector, 40 would be their required setback. So the variance requested here is 12 feet. And that's the case records we have it. Sir, ma'am, if you would identify yourselves and make your presentation. Is there opposition present to case 17? We do. Both sides will have 15 minutes to present their testimony, and I'll turn it over to the applicants at this time.
Good afternoon. I am Jo Emily Smith. This is my husband, Daniel Smith, and we deferred from the February 16th meeting and came back with the requested drawings. We contacted an architect. I'm afraid that we didn't actually realize that there would be opposition today because there was no opposition at the last meeting, so we weren't prepared for that, but we did bring what we had discussed with the board before and brought that, which is the front elevation, end elevation. I did bring you today the end elevation made a little larger because it was a little small on that paper, and also a letter from the architect speaking to the tree in the back. We do have a deck back there now, but it sits on footers as opposed to a full foundation, which our proposed addition would be a full, not just a dormer, but a full addition, and it would kill that tree. So, did you have anything?
They will still get rebuttal time, so anytime you don't use now, anything that comes up from the opposition, you'll be allowed to address.
Okay.
I'm not trying to step on anybody's toes. I'm really just trying to save time here. I don't think you knew you had opposition, and one of the most compelling things about your case last time is that you were in a neighborhood that often discusses land use issues and didn't have any opposition. The fact that you do have opposition, would you like time to discuss it with them in the meantime? And in other words, another deferral, and I'm not just deferral happy, but it is, oftentimes people can work things out with time. So, I mean, if you say no, we've deferred once, we want to hear the case, that's fine. It's
we could also move it back on the agenda. I mean, it doesn't have to be, till the next meeting. I mean, it could be right. 30 minutes from now or whatever, if you're interested, or you can just wait and hear what they have to say.
I'll let you show a hand of opposition.
There are 3, and then the councilman.
Yeah, I think hear from them. And
Okay. It's being suggested that it's best we hear from the opposition first. Okay, so if you want to save your time for rebuttal, that's great.
Okay, would we then have a chance to speak to the opposition afterwards, after we hear it?
I think it is always your option to defer. Is that not right, Joey? Okay, it's always your option to defer.
If the opposition will come forward in case 17.
Hi, I'm Rob Robinson. I'm a neighbor at 3707 Murphy Road. I'm also vice president of the Neighborhood Association. And did want to speak in opposition to the setback request. I think the concerns that Councilman Holloman addressed were valid, and I'm supportive of his opposition as well. My reservations, both as a homeowner and as a neighborhood member or association member, are a few different things. One, obviously, damage to the historic character of the home in the neighborhood. Secondly, the possibility of setting a precedent for other homes having variances along the way, and that hurting the character of the street, especially as a collector street with a lot of traffic. And then, frankly, my third concern is safety. I think it is this exact house a few years ago. There was a car that veered off the road and actually landed in the porch of the current house where it is. So to bring part of the property, certainly where anybody would be spending time on a regular basis closer to the road, is a big concern of mine. People tend to speed, and we get a lot of traffic on Murphy, so all 3 of those things would be significant to me. I think our association in general would certainly be amenable to the possibility of talking further with the neighbors to see what could be done, and then also wouldn't have any concern that I can think of about a rear addition, although I understand there's some concerns about a tree in the backyard. So we'd certainly be receptive to talking about either of those possibilities. I am here on behalf of the association as well as a neighbor, and we have voted unanimously to oppose this, as from what we understand at present.
So had you seen these elevations before you voted on it?
No, and Councilman Hallman had actually asked for them a couple of weeks ago, and we had not received any response. So having seen them, and obviously not having our members having seen them, I am still concerned because I see 2 stories there, and none of the houses that are nearby have something quite like that from what I can remember. It seems like it would not coalesce well with the other homes near it, but certainly I'd want our members to have a chance to react to that too.
So you hadn't had an opportunity to speak with them at all about this before you came today or voted?
Right.
Is there a reason why there was no opposition when they were here a month ago?
We found out about the hearing late and just couldn't be here.
Joey, I'm just asking for the record, but I'm assuming the proper notice was given and
Yes, sir.
signages were in place?
Yes, sir, they were.
Thanks.
Honestly, we were relieved when it was deferred because we hadn't had a chance to weigh in.
So is there anything that, do you see room for compromise? Or, is your opposition solely that it's on the front of the house?
Well, my main concern is that it's on the front, but I'm certainly willing to have a conversation and see what opportunity there might be.
Okay.
Did you have anything else you wanted to add, or?
No, that's it. I just wanted to make my case.
Actually, I do have another question. So if do you have the power, if you guys discuss it today during this meeting with the homeowners, do you have the authority to change the position of the board?
No, we would have to meet to discuss that. I can't do that on their behalf.
Do you have the authority to negotiate on their behalf?
No, not legally.
Okay.
I'm still a little confused as to why there are signs put up notifying variance hearings and things. And I'm assuming that process went forward before the last time they were here and there was no opposition. And unless there's I'm just concerned why there was no opposition the first time, and
Yeah.
suddenly there is.
No, I think that's a legitimate concern. What I can tell you is as soon as I learned of it, I was concerned, and certainly the councilman and I talking about it have been concerned throughout this time, but we weren't able to be here previously. So I apologize for that. I realize it may have made things more complicated.
The other fellow who's in opposition as well, would your points be the same?
Yeah, they are.
Okay. Okay. Young.
Name on record, or?
Yes. Could you put your name on record, please?
Sure, it's John. Last name's Houghton, H-O-U-G-H-T-O-N.
And is it? Oh, I'm sorry.
Live at 4412 Utah Avenue.
And is there anyone else in opposition? Because if we do defer, those people who spoke could come back.
Yep.
Okay, so if there's no more opposition, I'm going to ask the proponents to come forward. Sorry, I spent some time on the councilman side of these things, and so I have found before that talking can bridge a lot of gaps, and at this point, where y'all haven't even discussed it with your neighbors, that puts us in a difficult place. And truthfully, when a homeowners association is unanimously against and the councilman's against, that carries well, not from a legal standpoint, but just from a coloring standpoint, that does cover some ground. So I think if there's a deferral, there's an opportunity to bridge the gap if you are willing to consider a deferral.
Do we make our rebuttal to their comments now, or do we choose to defer now?
You could do either. You could do either. Well, anyway, maybe I'm putting all my preferences on this too much, but to me, what all's said in advance kind of hardens people's positions, and it's almost better to hear each other up close and personal first. That's just one man's opinion.
You know, I'm actually, you know, I was the one that pushed for the deferral the first time, and I'm actually more inclined to say, you know, if they're willing to talk now,
Okay.
and talk to the neighbors, and maybe they can't reach a decision, but maybe they can make a more informed decision of whether they want to defer or not, or take their chances on us voting now and them answering rebuttal questions.
Okay.
Because that way we've heard from everybody, and they can say, yeah, we want to defer, you know.
Okay.
So you're saying move this back to the calendar a little bit? Or give
No,
it
I would actually, it's up to them, but my course of action would be let them rebut what we've just heard. We can follow up with questions, and then let's defer to the vote if they want to talk in the next room, and they can come back and say, we'd like you to vote, or we'd like to defer.
Okay. That's
I mean,
fine.
but that's not how we have to do it. That would just seem to make sense to me. And
Okay. Okay. Speak away, please.
Thank you. Just a couple of points. Our house, to our knowledge and the research that we did ahead of time, is not actually considered a historic home. The accident that was referred to, I did actually live in my home when that happened, and it was the property next door, the 4003. I was actually one of the first people to call 911 that day. But at any rate, 4003 is also a two-story home. It has a basement, a main level, and a second story, which was a little bit what we modeled our drawings after. We also modeled it after other homes in the neighborhood. We actually went out and took pictures for our architect. We are very concerned that there's opposition that we didn't have time to respond to or to talk to anyone about, because we were not contacted for the elevations. We had 30 days to get them. We pushed our architect for today's date, not for 2 weeks ago, but we would have if we'd been aware of that. In addition to the zoning letter that was sent out, I personally sent letters out to everyone whose address was provided to me by Linda. I don't remember her last name, but the nice lady who Linda provided me a list, and so I personally sent out letters. And again, we understand that there is a homeowners association, a neighborhood association, but we didn't realize that they actually had authority in what we did, so we didn't go to them. We will admit that, but we didn't realize that that was a necessary step in this process. Did you have anything to add?
Just so we're all clear, I don't think anyone's accusing y'all of short-circuiting the system at all. That's not the accusation. It's just these things get out at a slower pace. And I think you're right that the homeowners association probably doesn't have authority. It's just a group of individuals that get together for the betterment of the neighborhood. And so, but I don't think anybody's accusing y'all of short-circuiting the system whatsoever.
are you members of the neighbor? Okay. Well, I personally think, I can save this for discussion, but I mean, they did what we asked them, and I don't recall anyone having any opposition other than my concern about the feasibility with the tree and the general massing. So I just put that out there. And thank you for getting us the drawings that we requested.
Yeah, the main concern by the councilman was the setback and coming out the additional, and I can't remember if it's 2 or 3 feet from the porch. I remember us having a discussion about, it being maybe 3 or 4 feet, from the porch. And so not really adding, as much as we originally had thought. But it seems like that, and I know that you're not bound by the guidelines of, Metro Historical, but it does seem like that there are some opportunities for compromise in terms of, you didn't take those 3 feet or didn't want those 3 feet in the front of the house, you wouldn't even need to come to us, you know. You could do what you want to do. So I guess I'd like to understand, you know, why the 3 feet? You know, I mean, what is the passion about wanting to, you know, to have that type of facade when if you wanted to increase your home by a certain amount of square footage, it probably could be achieved in a different way?
Thank you. It is actually 5 feet from the current porch, which we currently have some boxwood bushes there, and that's about the amount that it would come out. And the intention is not just to add the upstairs square footage, but to actually increase the downstairs square footage, which would allow our living room to be bigger. It's not very large now, and it would also allow us to put a bedroom downstairs on the front of the house. Whereas if we went to the back, the interior structure of the house is such that there's already that second floor over the living room at the front of the house. There isn't at the back of the house, so it would be quite a bit more construction-wise to go out that way. Did I appropriately address? So, I'm sorry, the reason that we actually want the additional footage in front of the, like our porch line is on that 40-foot, which I think is kind of grandfathered in. The codes have changed since that was put in. We wanted that addition so that we could actually put a proper additional bedroom on the front side of that house. So that was our intention there.
And I have a question. One of the concerns that the councilman raised, and I believe the opposition raised, relates to the setback. And do you understand what they mean by the change in the setback on the street that this addition will result in? Do you understand what they mean when they say that by adding this addition to the house, it changes the measurement of the setback on the street?
Yes.
I believe we did, yes.
Okay. And just, I'd be interested in hearing your response to that concern.
I guess you're referring to the variance between the present position of the house versus the other houses in the area,
And then
right?
what will happen in the future?
Right.
So to clarify that before you answer, I want to make sure I understand that Joey, if we grant this, then the new position of this house affects the overall average because we've set it, or does it not?
It would affect the average for the adjoining properties. Just like in this home, we looked at the homes to the left and right to determine its setback. We would do so on the adjoining.
But only in that way, and in no other way is it a precedent. We're not making a precedential decision for any future variance. Now, it changes the average to where people can build too, but just because we grant this doesn't mean that anyone else gets carte blanche on the next variance.
That's correct.
That was raised by the opposition.
Yeah, that's what I want to say.
Thank you for clarifying that. I think we do understand that what we're asking for and that we're asking to come out further than our neighbors. And we do understand that the research we had done originally just said the 40-foot, and now I think there's an update that's the average. And we do sit, let's see, 4003 is at 43 feet, and I think 4007 is at 51 feet. So it's back a little further, and it's also a very small home, even next to ours, which is next to 4003, which is quite a bit bigger, and then the one next to that is even bigger. So we understand that we are asking for a change, but one of our favorite things about that neighborhood is that it is eclectic. It isn't a subdivision with as many rules and everything looks the same. That's one of the reasons I purchased there to begin with, and it's one of our favorite things about the neighborhood. Now, in our immediate, like if you're standing in our front yard, the houses that you can see, there hasn't been that much change of recent years, but just a few streets over, there is constant new construction, and perhaps that's more what we were looking at when we looked at the changes that we would like to make is some of those newer things. But again, that's one of the things that we appreciate about the neighborhood is that it does have a diverse look, and that there isn't a, I don't know the right word, but
uniformity.
Exactly. Does that help?
One other question. This would be solely for your own residence and use, right? Not as a spec?
Yes, sir, solely for us, for sake. Our intention is if we're
family.
if we're able to do this, then we can start our family and stay here and not move anytime in the foreseen future. I mean, we're trying to turn this into our dream home so that we can stay on a relatively permanent basis.
If there are no other questions,
Mr. Chairman, for procedural purposes, if there's a intent of this board to let them go talk and come back to them later in this meeting, this public hearing needs to stay open. We don't need to close the public hearing at this point. If you do, you'll sort of need to make a decision. You can always decide to defer. That's one option. But if you decide to, and the reason I bring that up, most instances, you all, when parties get together and talk, we're deferring it, come back in 2 weeks. We're in the same meeting time here, so I want to be sure if there's an attempt. And I want to give you the procedural facts. If you're sending them off for 30 minutes or so, then this public hearing needs to stay open so when they come back, they can testify in this case.
Yeah, remind us of what your construction time frame was. If I remember correctly from the first time you came, it was, you really wanted to come and we felt like it was cart before the horse, which is why we asked you to go do a little bit more work for us. But it sounded like that it wasn't an immediate construction, that it was something that you wanted to do over, maybe within the next several months, but not start immediately. So it sounds like there would be time. A deferral wouldn't cause you a hardship necessarily in terms of your construction time frame. Is that correct?
I think probably a correct statement. We haven't actually hired the contractor because we felt like we needed permission from the board before we hired a contractor, but our intention was to get this project underway as soon as possible for completion this spring or summer. So we feel personally up against a timeline, but
I would like ultimately for it to be their decision. But again, my suggestion would be to leave the meeting open and come back and hear this at the bottom of the agenda.
And vote.
And vote, or them ask for a deferral.
I'm A-okay with that, but to reemphasize, the people they're talking to don't have the authority to do anything. I mean,
well, it sounds like even if it doesn't sound like a legal entity as a homeowners. I mean, it's not like they have veto power anyway. It's more of a good faith neighbor discussion, and I mean, let's not forget they didn't show up the first time either. I mean, the homeowners have done everything we've asked them to do, and again, I mean, if deferral is what ultimately they want, I'm okay with that. But I feel like if they want to vote, then we should consider that.
Okay, but I don't mean to sound like. I always agree with talking, and if they want to go talk, and I agree that a homeowners association is a loose affiliation, which doesn't have the power. I will say, but we're putting and I literally agree with every word you say, but we're putting our president of the homeowners association in a tough situation because he's got 45 minutes to go talk to people. He doesn't have the authority. I mean, it could definitely be in good faith. And I've dealt with a lot of homeowners associations, and they're not all united at all. And so, anyway, I'm never opposed to people talking. If they want to go talk, go talk. But I do think they need to know that they're talking to people who don't have the authority to bind, and the people who don't have the authority to bind are in a tough situation because they literally can't speak for the whole neighborhood because there are new facts. So anyway.
That brings on another question. If we do, say, move this back and have them go talk, and we keep the public hearing open, the opposition, are they entitled to come back for any response at all after they talk? Normally not, when they have no rebuttal time. But would it be unfair to the opposition to not let them speak after they discuss, or is it,
Well, I think there are rules, so we could waive our rules.
I'll ask our counsel that question.
As a practical point, no, it would not be unfair. And this is a very practical analysis for even if this. The idea is that if they were coming back afterwards and wanted to rebut more, they've had their chance to rebut. And we understand that if they're coming back at all with anything other than, oh, hey, we've worked it out, it's understood that there's still some degree of conflict or opposition to the project as presented. So again, I know it's a very practical analysis and doesn't dig into the code to give you that answer, but I think we're probably fine on that.
Well, I also think that we do have their stated opposition, which I gather, if he indeed was speaking on behalf of the group, he gave us the 3 or 4 reasons, and and again they hadn't even seen it, so yeah. I think we have them on record, even if they, and again, they can go back there and talk and decide we can't come to a decision, we want a deferral, or we can't come to a decision, we want to vote. I mean, we can come to a decision, we're okay. Please vote.
Okay, I'm never opposed to people talking. Does that sound like a plan to y'all?
Yes.
Okay, then we'll move you to the heel of the agenda.
Can Joy or Linda set them up somewhere?
But we'll find a spot for them to sit down and talk. Okay, Mr. Chairman, that case will heel that to the end of today's agenda, and I'll go ahead and call the next case before us, case 2012-23. Cummins Signs is the appellant, P&M Investment Company, LLC, the owners of the property at 1901 8th Avenue South. They are requesting a variance in the street setback and in the CS and UZO's district to change the faces on the existing ground sign. And I have to install a reader panel. Gentleman from Cummings, is that still proposed to be done? Yes. Okay. This is referred to the board under Section 1740-690D. The appellant has alleged the board would have jurisdiction under Section 1740-180B. The current use is a financial institution. The subject property is located on the west margin of 8th Avenue South, just north of Wedgwood. This location was a former Miss Winters, and the current use out there as a financial institution, a permit was obtained to change the use from restaurant to that. The code section that I cited, 1740-690D, talks about non-conforming signs. This sign is a legally non-conforming ground sign. Let me get to the picture. This shows the sign as it sits today, and I'll focus your attention to the bottom right photograph. Its nonconformity is based upon the setback of that sign. When the sign code was adopted in 1993, they allowed signs that sat too close to the road. If they were raised over 10 feet and taken out of the visibility issue, they were allowed to remain and stay where they were. The idea being that if the ground sign was too close under this new adopted code, and I use the term new as of 1993, rather than force all the business owners to remove the signs and demolish the structures and rebuild in compliance, they would let them move those sign panels up above 10 feet, and Metro would honor those as being fine where they stand. Section D talks about, unfortunately, on a single tenant lot, which that's what we have here, as opposed to the parcel which you see north has multiple tenants on it. In a single tenant situation where the land use changes, and the code says for single tenant lots, a non-conforming sign shall be brought into compliance with this title when the principal land use on the lot is changed to a different use as described by the district land use table. So here in end of 2011, 2012, the use of the property in 1993 was a restaurant. Permit was obtained, taken out to convert the structure that was former Miss Winters into the financial institution you see. The existing ground sign was required to be brought into compliance with the setback, which would require a 15-foot setback off of the, a 10-foot setback off of the property. They're approaching you today requesting to leave the ground sign where it sits today. It's approximately 3 feet from the right-of-way, and seeking permission to reface that ground sign. And that's the case, Your Honor. We have it. Before I begin, is there any opposition present to case 23? Mr. Chairman, seeing none, applicants will have 10 minutes to present their testimony to the board.
Hello, my name is James Murray. I'm with Cummings Signs. I'm here representing Advanced Financial and ourselves as the contracting company. This sign, has been stated, has been here existing for 15, 20 years. Right now, all we're looking to do is leave it exactly how it is, and all we've done is change the color of it and put new faces into it. We're not looking to, we would much prefer be able to keep the sign where it is, because you can't really tell in these photos here, but if we were to move it back, this is a straight-on shot. If we were to move it back 15 feet, it would be completely blocked by the building itself. If you need this, I'm more than happy to push it forward. But at this point, it is in line with the signage next to it, and we are looking to basically keep it where it is, the way it is.
So you guys had a permit to change the sign to what it is now?
The way it came out is we had pulled the permits, we had run through everything, and then this code was brought to our attention after the fact. It was missed for the most part. We had to change our subcontractors that did the installation last second, and at that point they had to pull their names, and then it was brought forward.
Yeah, Mr. Harper, what occurred, they had a different sign contractor apply for the permit. That work was done, as you see on the face, the work was done without a permit. Cummings approached us about obtaining the permit, which we said, this change of use provision requires you to push it back. But the work prior was actually not done by these gentlemen, but by another contractor without a permit.
And this is the same structure?
Correct. It's the same exact signage that has been there for the entirety of that lot. All we've done is change the paint and change the faces.
That was the Mrs. Winters, you just changed the face?
Correct.
I'm sorry, I'm evidently pretty slow today. Joey, this is just the same issue again, that the changing of a panel equals the changing of a sign?
No, it's really, it's different. This provision has been in the code since '93, and they only put it on single tenant parcels. In cases that came later dealt with multiple tenant parcels, and whether the change of a face is a destruction of the sign, that's still being battered around Metro of what the government's ultimate position by way of legislation is going to be. But this was an example that took in '93 when the sign code was adopted. Like I said, rather than force all the tenants to take down their signs and rebuild, so long as they moved them up and got them out of the visibility zone, that we'd allow them to remain. But this clause was put in here with the intent, if that use changes, then you're going to come into compliance. The structure itself, in your question, Mr. Harper, this is the same everything except the panel on this. The structure itself still has the non-conforming sticker upon it that we placed in '93 when the sign code went into adoption.
Is there opposition?
No.
Okay.
Are there any other questions? Discussion?
So clear me up on the use thing you're referring to, Joy.
Yes, sir. Well, the prior use of the property was a restaurant. It was Miss Winters fast food restaurant. And the code section here that I'm talking about says, we're okay with the sign as it is in 1993 when this code was adopted. But if that use changes, and the council and the folks that drafted this picked use as being the demising line, when the applicants came here to obtain, they took out a permit. I'm looking at the permit history here. They took out a permit to change the use here in November of 2011. That changing of the use and subsequent request for a ground sign here is what triggers this section of the code of having to take this sign down and push it back to 10 feet.
So if this were another fast food restaurant or another restaurant, it wouldn't matter?
No problem. Or if this building had multiple tenants, and then the theory behind that was we don't punish all the tenants in a building for a non-conforming sign.
Joey, can you go back to the picture, the
Sure.
actual picture of the facade?
So in this case, the use of the term use is relative to the use of the building and not the
That's
use
correct.
of the sign.
Yes, sir. Well,
Okay.
the sign is in and of itself, in some courts have argued it's a use in and of itself.
Joey, so in this case, if we were not to approve of this, they would be required to move the sign 10 feet back.
Correct.
Could you go back one slide before this one?
Which is like a parking bay. A little more than a parking bay.
Oops, sorry.
Is there, I'm sorry if I missed this at the beginning, but this is, for whatever the sign becomes, it's not a height to distance ratio or anything like that? It's
There's
just
nothing.
This,
There's
this
no
sign
sort of-
would have to move. Okay.
Correct.
Okay, and so nobody's alleging that the state statute on grandfathering applies or anything along those lines, right?
No, sir.
Do we have any other questions for the applicant? Okay, then we're going to close this and go to discussion. Close the public hearing and go to discussion.
Well, I see the code. I mean, clearly the use of the property has changed. And is this a hardship or a D or what?
They're requesting a variance in
Right,
the setback.
This is a tough case because it's of no fault of their own, it seems like, but there is room to move that back 10 feet.
Where are we on the parking?
That's the,
Hold on.
I'm sorry, we already closed the public hearing.
Did I miss anything on the parking earlier? Are we okay on the parking? Are we over numbers, under number? There's 13 spaces. Joey?
Give me 1 second.
Oh, okay.
Let me check to see.
Looks like you go right into handicap.
Well, it's just about.
I was thinking I needed to open the public hearing for a second, but I found the information I'm looking for on the size of the building. The parking's a function of the square footage of the structure. Yeah, the number of required spaces here would be 13. Required based on 2,613 square feet in the building permit to rehab it to Advanced Financial.
And 2 handicap spaces?
The handicap spaces are required under the building code. I don't know the number. I can't really speak to that. They are required to be as close to the principal entrance as possible. And that side entrance that you see in the prior photograph over here is just from pattern, what I saw out there for my time period, most folks came through that door. The handicap ramp is run to that. The striping, which you see in the parking lot, is run to that door on the side. There is a ramp here along the front that would allow handicap access.
Well, I was asking that because it appears if the sign moves, then they would lose a parking space, and they have 13 spaces.
And there are no spaces on the south side of that property.
Yeah, I mean,
Maybe we should reopen that just to ask about that.
So it looks like the shape.
Can I ask you, David, where are you getting 13? Because I'm counting.
Well, on the side property, I'm looking at this drawing, but I was looking at the area photograph. It looks like there might be more.
On the picture, they're only, I mean, on the site plan, there are only two.
Well, there's a number
There's
that's.
three back
there's
there.
a-
Okay,
Maybe
thank
we
you.
should open the public hearing again
Yeah.
to ask that question.
Okay, let's,
four back here.
okay, motion made, I'll second to open up the public hearing to ask the question.
All in favor?
Oh, all in favor, sorry.
Aye.
Sorry about that.
So, let me go ahead and ask the question. How many parking spaces do you have in your existing plan?
Cullen Ernest, I represent Advanced Financial. I cannot tell you, I'm sitting here trying to count by looking at that thing. I do not know off the top of my head how many spaces there are, but what I can tell you is that yes, we would lose a space if it was moved back. And again, well, I guess I can't address another subject right now.
If you open the public hearing.
Well,
We opened it
it's not
for,
rebuttal. It's not rebuttal, so I guess you could.
no, I'm fine with it. I mean, does anybody else have a problem? Okay, sure, speak away.
And just back from a layman's 30,000-foot perspective here, our request was that since this particular pole had been in the ground for 15 years or so, and it was just the verbiage on the sign. Had we been a Burger King instead of an Advanced Financial that had moved into this, then we would not be sitting here today. So we requested this because of this particular instance that it would not have moved had that been the case. Nothing was changed in the sign. The sign was not made any bigger. It was just a matter of what is happening inside the building.
I mean, I'm sympathetic to that in the sense that the sign was there. Why couldn't you put a new sign? But what I guess I'm hearing from Joey is, when the Metro Council passed this rule, they said, no, when the use changes, this is when we want everything to conform. And so then I would look to, well, what's the hardship? Is there a hardship there? And I drive down this street a fair amount, and I remember when you all were doing the construction, because it's very obvious you're changing Miss Winters into something else, and it's nice to have a new and hopefully thriving business there. But this building sits much closer to the street than any of your surrounding neighbors. So I guess I'd like for you to address the hardship question specifically as it relates to your ability, anyone's ability driving down that street to see your signs, because I think you have signs on the side and the front, and I don't see an obvious hardship that says we wouldn't know you were there if you didn't have this existing giant sign.
And I will say that the gentleman from Cummins did mention that moving the sign the building would block it. And what we're fishing for, not to speak for him, but at the end of all this, we have to find a hardship. We're required to state a hardship when we vote for this.
And I have to add to that, I count 15 spaces.
Okay. And by the way, by hardship, it doesn't mean on you. It's a hardship based on the property. I mean, based on the size, narrowness, depth, terrain,
For many
something.
people, coming here is a hardship. So
Yeah.
Yes, sir. I mean, I could sit here and tell you how much it would cost us to move the sign, and believe me, I would consider that a hardship. I know what you mean. But yes, going back to his point a few minutes ago, and that would be if you looked at it from a particular point of view, the sign moves back behind the building. And yes, we would absolutely consider that as a business owner a hardship for sure.
And if you do take a good look, it does actually, the way that the sign is set right now, you would be losing 1.5 spaces. It's not just one space. You'd have to take it down at least 2 spaces, and then you might have to restripe the rest of the pavement just in order to make room.
But doesn't food service use require more parking than this particular business type use? So would the parking requirement be reduced accordingly?
For square footage.
Right.
But they have parking in the back.
Right.
The prior food service use was grandfathered on parking. They're short under today's code. Yes, sir. The parking requirement is different. It's actually double what this one is.
This also has vanity, so I don't know that the aerial. I'm not sure that aerial photograph represents the number of spaces that are in this drawing, or that's in the current plan.
If I may add something too, this type of establishment, this type of business, when someone used to, I know there are parking spaces in the back, and believe me, security is one of the most important things to us. There are cameras all outside of that building. There is a dark alley back there behind the building, as you can see. And the 4 spaces that are back there behind that dark alley, these are people that are leaving after they cash their paychecks and that sort of stuff. Like I said, it's well lit and there are cameras everywhere. But as mentioned in the beginning, most of the customers go in that side door right there to the front, and it is a security issue for sure that these people are leaving, walking back to their car with money, especially with that dark alley back behind the business. So yes, it would definitely be my preference for people to park on the side that's well lit, that's next to the other business, as opposed to being in the back by that alley. So losing spaces on the side is a huge deal for us.
That's a preference, not a hardship, right?
It would be a hardship on the public, I would say.
Okay, any other questions for the applicant? Okay, close the public hearing again. Discussion? Well, I'll start. I do not see the wisdom of this law whatsoever. I mean, change of use, change the sign. But having said that, we're not the lawmaking body of the county, and no one's alleging that the Tennessee grandfathering statute, which would trump Metro's law in certain situations, governs. So I think we are doing exactly what David Harper says we're doing, is if there's a variance, then it's a possibility. But if there's a hardship with respect to the land, then there's a possibility. But if not, I just don't think it falls into our other sign category cases.
And I'm usually not this guy in this discussion, but I'm actually willing to entertain the combination of I don't know that it's unique building location on the site, which is a function of what they inherited. The building is where it is. It's not necessarily because of the shape of the lot or the slope of the lot, but it's where the existing building is. And also the security, issue is, it is, to some degree that is a function. Not being able to park in the back or not preferring to park in the back isn't necessarily a hardship, but I can see how it could affect the business. Again, because it's an existing building, this is where the entries are. So I can entertain that as a hardship.
I probably should speak up now. I probably have to hear more discussion about the security issue, because I'm not convinced that that's a hardship. I think that the intent of this was that if the use changed, it was supposed to fall into conformance, and I'd have to hear more on that. I have to tell you, I'm not swayed by that.
Well, and just to frame, I was simply trying to frame what I think our legal requirements are. I'm not against the fact that it's a hardship, and if they lose 2 spaces, and I do think it's a bit compelling that there's a dark alley back there. So, but anyway, I'm more than happy to hear more discussion on the effects of the dark alley.
We just have to find the hardship, and if we or a majority of us agree on that hardship, then essentially it's up to the people up the chain if it's appealed by an aggrieved party. I guess I'm taking the IBA point of view also of it's to me it's de minimis in that the sign is there. It's not a view problem. And I don't know that moving this sign 10 feet back changes. I don't know if there's any net benefit other than it, completely brings it up to code. But that's the other thing that our legislature gave us, was they gave us this board to consider this. So assuming we can find a hardship, and we might not.
I don't personally see a hardship. I don't.
Well, that puts it closer to the light.
will move that since we find, or I see no hardship to support a variance, I would move that we deny the request.
Got a motion? Do we have a second?
Not yet.
Not yet. Okay. So we've got a motion hanging out there. Well, let me ask a question, because the closest I can, well, the arguable hardship I can see is that you have a narrowness of a lot so that you can't have parking on both sides. You do have an anomaly in the back, and that it backs up to an alley that's dark. And if you move the sign back, you are going to lose 2 spaces and arguably have the sign blocked. Now, I'm not sure any of those 4 standing alone is compelling, but if you throw all of them together, I don't know if it's compelling. That's just a question for the group.
How does our council feel about? I've never really been clear if
Council feels you are doing a bang-up job on this one.
Okay. I know that we have to find. Does the hardship have to be requested or stated, or is it can we derive?
Determined by the board.
Okay.
Well,
and I tend to agree with what Chairman was saying. Given that, I would be more in favor of granting the variance.
it doesn't look like a dark alley to me, but I'm mindful of the fact that these are people who may have cashed their paychecks, and if that's the only entrance and it's hard for me to see and they have to walk all the way to the back, I am deliberating whether I think that that the shape of the lot is going to create a difficulty in providing visible, safe, and secure spaces.
It's dark. It's not dark now because it's daylight in this picture.
It's not dark all the time.
Not all the time. Just at night. Just the winter.
Mr. Chairman, as your secretary, I'm going to have to call a point of order. You have a motion without a second. That motion fails for lack of a second. To keep you on course with the procedure part of it. So if there's another motion to deny, it needs to be made again.
Mr. King, I want you to know I did not bring that up. That was your secretary who picked on you.
Kind of my duty to do, unfortunately.
We could defer and have them talk to some of the other parties.
Yeah, I know.
Yeah.
All right. I like to hear you.
I mean, the difficult thing that I'm struggling with is that, you know, there's a clear intent of if things change, we want things, you know, we want codes to be fully enforced, and I appreciate that. And I've been through that in a business that I have, and I understand sometimes the absurdity of it, or at least the seemingly absurdity of it. And yet at the same time, this particular sign, I mean, the sign's been there as long as I've lived in close by, and I just don't think, like I said, I agree with the chairman. It's not, the rule in this case just doesn't seem to make much sense, but it does seem to be the rule. And so I always struggle with the question is, if you don't enforce it now, when will you have a case where you do this? But at the same time, I've been down Wedgwood and 8th Avenue at night. I don't think I would want to cash my paycheck at 4 o'clock in the morning and walk to the alley. So I respect that point of view also. If that's an appropriate hardship, I'm with you. I don't know. I'm kind of 50-50 on it.
I think I have one more question before I'm prepared to take a position. Joey, can you take us back to the front facade of the building? And he has. The thing that I'm looking at now is that this building is closer to the street than the other buildings, meaning they're advertised. I mean, they wouldn't be denied per se the ability to advertise their business.
Well, that was
because
kind
they're
of
so close to the street.
what I was thinking, and thought I had commented on the other, a little bit ago too, is to say that, with those three signs, the two we see and the one on the other side, lit, there's no mistaking where you're going. I think if the sign, if it were moved, it might create a hardship. I think if it were taken down because it didn't conform, I don't think anybody going down that street would not know that Advanced Financial 24/7 was right there, because you do have that clear view. So, like I said, I'm kind of struggling with it.
Well, I agree. The intent of the council action was to try to clean up the city and to set rules to do that. And I see this as one avenue to do that. I mean, clearly the use of the business changed, and if we don't start upholding that, where do we start? I mean, if it was a clear hardship, I could go with it, but I do not see a hardship. I mean, we can create one in our mind if we want to, or search for one, but I just don't see a clear hardship in this endeavor.
Okay.
Sorry.
Go.
I was going to ask Joe if you could go back to the picture that showed from the street, the sign. Yeah.
Maybe create parking in front of the building.
And so it needs to go from where it is, it needs to move how much?
The records we had from the original sign showed a 3-foot setback. I can tell you with my eye, I don't see that here. We measured ground signs from the closest edge to the right-of-way. Closest edge in this point would be this line here. If I come directly south, I don't believe there's 3 feet between the back of the sidewalk and that plane of the sign.
But it's the back of that sidewalk, then it needs to be 15?
Well, 15 if it's below 10 feet, 10 feet if it's
so
above.
it needs to move 10 feet, the face of the sign, the leading edge of the signage needs to be 10 feet behind the sidewalk line.
The replacement sign as well would have a side setback away, in this picture, be coming towards you.
Oh, so it'll be in the parking spaces.
They would actually be a 10-foot setback required from that adjoining neighbor too. It would.
So not only would it be in a parking space, more likely it would be 2 or 3 parking spaces.
Potentially. Because the sign itself at the poles would have to be 10 feet off the neighbor's line. That existing sign, as you can see, it's nowhere near 10 feet from the adjoining neighbor north.
Can you go back?
Sure. Oh, sorry. Yeah. Let me get you. If you'll give me 1 second, I can blow this photograph up. Maybe give you a better view of it. This is the sign. You can see the shadow cast by it here. That white car, which you see there, is the first stall, which you see here.
If they needed signage, I could see it, but the building itself is pretty well signed, so I don't see, even if they lost the sign, what would they be losing except vision coming further down the street? But
This is an extremely tough one, really, really tough. And I think we're struggling because we're struggling to find the hardship, understanding. So I think we're all struggling to find the hardship, and as difficult as it is, I am going to move to decline the request for a variance on the basis that there is no hardship.
I'll second that motion.
All in favor? Aye. Any opposed? Okay. Okay. It's unanimous against, or unanimous in the denial. This is a good time to again say we're not the lawmaking body of this county.
Mr. Chairman, you had deferred the prior case, case 17. Those parties have met. Would like to approach you at this time, if we could.
Great.
Parties for case 17, Mrs. Smith's 4005 Murphy Road Avenue. If both sides would come forward, please, here at the table. Mr. Chairman, I bring them up at this time rather than the end of the meeting. A couple of the parties need to depart and would not be able to make it to the very end of today's agenda, and they have met and discussed. So
Okay.
that's why I'm not bringing them at the very heel. I'm going on and bring them now.
Okay, please speak away.
Well, I'm happy to let them speak as well, obviously, but it might make sense for me to start. After we talked, I do have a better understanding of what they have in mind. I can't speak for my association, obviously, as we talk to, and I think that preference likely would be that we'd still love to see it in the rear rather than in the front. However, I'll say more about that in a minute. And I still am a little concerned that someone may be able to use this as an example in the future to do similar things. But all that said, I am less concerned after hearing what they actually have in mind and the way that they needed to field the request as far as how much of a variance they're actually asking for. 13 feet sounded like a lot more than what the practical application will be, considering that it's grandfathered in. So I can't tell you that we wouldn't still oppose it, but I can tell you I'm not as worried having seen what they have in mind.
We appreciate your time in the conversation. We appreciate the board giving us the opportunity. I think there was some confusion over thinking, when we heard his point of view, we understood that he thought we were coming from the existing porch line out 13 feet, which would be obnoxious. We will admit that. So, however, our concern in talking about the rear addition is we still feel that that's not a practical application for our home with the tree in existence. So I think we would like to go ahead and ask the board to vote. Did you have anything to say? If you'd be so kind.
Oh, okay. Yeah, close public hearing and discussion.
I'll make a motion to approve the, Case 2012-17 on the basis of the unique characteristics of the lot. With the tree in the back.
I think last time we confirmed that there was narrowness on both sides and a tree in the back.
Yes, that's the motion.
Do we have a second?
I'll second.
Okay, we've got a motion, we've got a second. All in favor?
Aye.
Any opposed? I'd like to compliment the president of the Homeowners Association, too. One, he's given his afternoon, and two, he took a position where he might go and get chewed by a couple of his neighbors. So anyway, I actually think that's good leadership.
But I think it should be noted them as well. This is not a precedent. That doesn't case stand on its own.
All right, Mr. Chairman, you adopt case 17 on a vote of 5-0, hardships being the tree, the unique characteristics of such.
The narrowness of the lot.
Narrowness of the lot
as
well. Thank you.
Push through the next one.
Mr. Chairman, are you ready for the next case? Okay.
We are indeed.
All right. We'll call the next case, case 2012-24, the Sullivan Lunsford Family Partners LP, the appellant and owner of the property located at 535 Thompson Lane. They are requesting a variance in the rear setback in the IWD district to legally subdivide the parcel into two properties. Referred to the board under section 1740-370 and 1712-020. The applicant has alleged the board would have jurisdiction under section 1740, 180 item B. Is there any opposition present to case 24? Mr. Chairman, seeing none, the folks will have 10 minutes to present their testimony. If I let me queue up there. The subject property is located on the south margin of Thompson Lane. This is just east of the CSX viaduct that passes over Thompson Lane. Familiar with this property is the Hearth and Grill Shop that's located here. Additionally, there's also a business to the rear of the property. That's the building on the south portion of this, which you see here is and I'll show you in the photographs, appear to be storage lumber yard. The request for what the applicants are proposing to do is legally subdivide this property through the Planning Commission. They're proposing to put a property line between their structure on the north part and the structure to the south in this location as you see here. The new property line would be at the rear of the existing Hearth and Grill Shop structure. And by placing the property line here as part of a subdivision, this is this new parcel's rear setback. And the zoning code requires a 20-foot rear setback there. So as you see, they're requesting a variance of 20 feet. Additionally, as a subdivision, there would be some fire. I don't want to kind of clog things up here, but they would have to also discuss with the fire and building code folks about fire rating that wall. Those are things we'll handle in the plan side of it when it comes forward. But this is the subject property you all may be familiar with on Thompson Lane, facing south on it. This is at the back of the property, and this would be the approximate property line would run parallel with the back of the wall according to the survey provided. This structure to the left would be on its own fee simple lot, and then the Hearth Grill Shop would sit on its own parcel there. The street which you saw on the site plan is Seaboard Lane, is a private drive. It's not a public street here. So we don't have a setback implication off of that driveway there. But this photograph shows best where the area where this is occurring. Again, no construction occurring with this. This is a subdivision of land issue. And with that, I'll turn it over to the applicants. Before I do, is there any opposition present in case 24 again? Seeing none.
Mr. Chairman, members of the board, my name is George Mutter. I'm here on behalf of the appellate Sullivan Lunsford Family Partners, which is the entity that owns the Hearth and Grill property. With me today is Mr. Ricky Sullivan, principal in the Hearth and Grill Shop, as well as the partnership that owns the property. Also with me is Mr. Bob Harwell, who is the owner of Walker Lumber and Hardware, which is the property located immediately east on the other side of the private road. Just to put you in perspective, the property is on the west, abuts the CSX Railroad right-of-way. The property between the Hearth and Grill Shop and Mr. Harwell's property is owned by CSX, and there is a permanent easement that's in place that allows access to the rear of the Hearth and Grill property. A couple of other unique aspects of this is that, as you can see, the rear of the Hearth and Grill property is not really used as a traditional rear entrance. All of the loading and unloading, and that's both with respect to wholesale as well as customers, is on the easterly sideline, and so they really don't use the rear of this property as a rear lot. Now, the retail customers park in front along Thompson Lane and enter the building from the northerly side. The loading docks are which I referred to that are there on the easterly sideline. About 5 or 6 years ago, Mr. Harwell approached the owners of the Hearth and Grill about the possibility of using the rear portion of their lot to construct a lumber storage facility. And they came to an agreement, and the parties entered into a lease for that property. All the appropriate permits were obtained for the construction of that. Because the lumber facility faces the right-of-way of the private roadway, what we're dealing with on this request is the lumber storage facility is really a side setback, and in this area there is no side setback. There's approximately 31 feet between the southerly facade of the Hearth and Grill shop, which would be the proposed property subdivision line, and the storage facility. It is an open storage facility. But to emphasize, the point is that there's 30 feet between that, and for all intents and purposes, we really do have a setback there. The further facts are that Mr. Harwell has been advised that in connection with estate planning and possible disposition of his business, that the lease of the property would have a material adverse effect on his ability to market his business, because the use of that storage facility is now essential to the operation of the business. That is all I have. I mean, that's the configuration of the lots. The fact that they're at least the Hearth and Grill is pretty much landlocked by the CSX right-of-ways and owner of property makes this a unique situation, and presents a hardship in the ability to sell the property.
Mr. Mutter, I believe Planning Commission does the subdividing in our county. So you need this variance to even go to them for the subdivision?
I mean, what was on the screen is the proposed plat.
Okay.
We have met with the Planning Commission, and we had satisfied all of their other concerns. There was one concern about running a sewer line, and they agreed that we didn't really need a sewer line for the use of the property as a lumber storage. So subject to a variance for the rear setback line, I think that we are in a position to have the property subdivided.
Questions?
Well, so will this be a sold property? I mean, will it be attached to another property, or how do you access that if that's not on a street?
No, there's a private drive
that would service. I mean, like the private drive is owned by who? The new owner of this property?
No, CSX owns it, and there's a permanent easement that benefits the Hearth and Grill property.
I've just heard stories about what they call the Horizontal Land Act, that you can't have an isolated piece of property without access to a public road or a right-of-way. So that's what I was concerned about.
That is not a concern. I mean, the easement is long-standing. I think it's certainly been in existence as long as the Hearth and Grill shop has been in operation, and I actually have a copy of it if you'd like me to refer to it. But it's been there for at least 35 years.
Okay. Any other questions? Well, just to summarize for my own self, I think I've heard you articulate three hardships. One, the narrowness of the lot. Two, the oddity of the lot, that what we were speaking of as being the rear is really the side. And then third, that it is landlocked by CSX on both sides. Are those the three?
Yeah, well, to be honest, I'm sorry I misspoke. It's actually landlocked on 3 sides because CSX owns the land immediately south of this. So there's no opportunity to acquire any additional property that would allow us to have an alternative to remedy our situation.
Okay. Any other questions? Okay, then I'm going to close the public hearing. Discussion? Well, I'd like to make a motion that we approve the request for a variance based on the 3 hardships, which are 1, the narrowness of the lot, 2, the oddity of the lot that it's so long, and so what we're referring to is the rear is actually truthfully in all practical purposes the side, and then they're landlocked by CSX on three sides, so they really don't have a remedy. And the practical matter that we have 2 existing buildings, and it would serve no good whatsoever to make them tear down a portion of either building. Second. Got a motion, got a second. All in favor? Aye. Any opposed? Great. Congratulations.
Thank you.
Who said? Okay.
Mr. Chairman, the final case today, case 2012-29, Bellevue Baptist Church of Nashville. The appellant owner is the property is located at 7400 Highway 70 South. They are requesting a special exception for additions to the existing church, as well as variances in the perimeter fence requirements along an adjacent property, dumpster setback, and impervious surface ratio in the RS-15 district to construct new additions and a new parking lot expansion. The appellant has alleged the board would have jurisdiction under Section 1740-180, items B and C. The applicants are present. Any opposition present to case 29? Mr. Chairman, seeing none, let me go through the variances for the board. The subject properties today involve these 3 parcels. This is at the intersection of Cross Timbers Drive and Highway 70 South in Bellevue. This is an aerial showing the existing layout of the church site. Currently today, the church has a parking lot along Highway 70 and along Cross Timbers here and to the rear along Stacy Drive, as well as this former residence that's being used as church offices and the parking lot in that proposal. The proposal is to, again, this is the former residence that's being used as church offices for points of reference here. The proposal will be to expand the parking lot into the adjoining parcel here. That expansion into that parcel requires, along residential zoning, adjoining residential property is required to have a 6-foot opaque fence along that property line, screening the headlights from these parking stalls pointed toward the residence. The church has asked for a variance in that requirement, and they'll state the reasons why for their appeal during their portion. Again, also will be an expansion of a parking area in this location, and this location is being expanded to supplement parking that is being taken away by the proposed addition, which is in this location here. Playground area that I believe is that you see located in gray will be relocated to this site here. So again, referencing the addition here, this playground area would be relocated to this, and the parking lost here would be picked up in this area. Our office has had numerous emails and letters, copies of which you have in the file from the council lady, Sherry Weiner, and some adjoining neighbors. You have those before you there. The most recent proposal was the original plan showed I think a permanent egress out on Stacy here, which would be new. This is an existing ramp that's going to stay. The church has revised their plan to take this drive out and then to divert all the construction trucks, rather than using Stacy and Cross Timbers to get out, to use Highway 70 South only for the construction traffic that would come with the addition here. The ISRs before you, this existing church, they're acquiring additional land as a part of this expansion. At that point for us on existing church may have exceeded the ISR ratio that was on the site here. And the ISR ratio is the impervious surface ratio. That's the area of parking and buildings divided by the lot area. The maximum allowable ratio is 40%, meaning I look at this more as a reverse percentage there. And what I mean by that is when I look at the code talks about in this zoning district being RS-15. RS-15 requires that the maximum impervious surface ratio is 60%, meaning 40% of this lot has to be pervious. Grass, penetrable surfaces. We've now adopted provisions that allow for permeable concrete to count. The inverse of that is basically saying I can cover 60% of this lot with impervious materials. What they have here is essentially you have a 30%, after this is all said and done, you have a 30% area of the church's property that is permeable, and the code requires that be 40%. So I hope that explains that position there. But that's the case record as we have it. You have received correspondences again from the council lady, I believe, in support of the request, and also some letters from neighbors who are also supportive of the request. And with that, I'll turn it over to, I guess I better show you the photographs. Sorry. This is looking into the subject property. This picture is taken at the rear, and that's where the principal addition is going to go. The playground I referred to earlier is going to be relocated into this area. That addition will come off the back of the structure out into here, and this parking area that's being lost will be picked up in the background in this location here. I apologize. I had some camera malfunctions the day I went out there, getting that addition coming off the church here, this playground being done, and a new parking lot would be picked up on the north side of this surface lot. Along that tree line, which you see there, is Stacy Drive. That's the existing tree line that sits somewhere in this location today. And then the proposed parking expansion in front of the church offices that this former residence is being used at. But I'll leave the site plan up. With that, I'll turn it over to the applicant. Sir, you'll have 10 minutes to present your testimony. Thank you.
Okay. My name's Roy Gilliland. I'm the architect for the church and here representing the church today. I can pretty much empty your boardroom when we get through with this one. The pastor is here along with several of the church members. There probably is no opposition here today because we worked very hard to make sure there wouldn't be any, to the extent of even revising the plans at the last minute that you saw there. The first issue on the, the first issue is a special exception. Of course, the church has been there for since 1972. It's had 3 building programs. This is its 4th. In terms of the fence adjacent to the adjacent property owner, you should have in your file a letter from the adjacent property owner that says he doesn't want the fence. So that's why we're recommending that it be deleted. It is right at the end of the red arrowhead on the right there, and that's the only fence that is required by code. Let me come back to the parking lot. Apparently there's a dumpster set back that I was unaware of because I was told, or at least that's what's in here, but Joey, you didn't mention.
Yes, sir. That one, actually, thank you for bringing it up, Ms. Gilliland. That appeal has been withdrawn. The former plan in the northeast corner of this property, this dumpster here was actually in the setback. It's been moved out. Okay. So I apologize for that.
So I don't need to speak to that. No, the parking lot itself, the difficulty, well, first of all, the church is acquiring property when it can. The property that is being requested not to have the fence on it is, in fact, owned by a church member who is here today, and the church expects to acquire that piece of property when they no longer need it. The difficulty in churches is that churches attend at a ratio of 1 to 2 on Sunday morning, and to come up with enough parking for Sunday morning, which is the most important time, we have to have at least twice as much parking as code requires. So for that reason, we're asking for a variance from 40% to 30% on the impervious surfaces. And also, I would point out that all of this has been brought up to the community group. They don't have any problem with it. But to compensate for that, we have also, or my landscape architect has also met with Stefan, and we're putting in excessive tree coverage, probably up to 80% more than is required by Metro, along with using bioretention, which means the parking lot is broken up more in terms of green space, even though there's too much of it. So because of that, we are requesting that variance. I don't think the construction entrance is necessarily part of this board's concern, but because it was a concern of the neighborhood, we thought that we should bring it to your attention. So therefore, we are proposing the construction entrance onto 70, and we have deleted the additional entrance onto Stacy, which was requested by the neighbors. As of today, we have consolidated those 3 parcels of property that have been in question. Those are now one item and will eventually show up on your documents. If I can hand this out to the board. With nothing further to say, I guess I'm open for questions.
Questions?
Just on the impenetrable surfaces, Joey had just talked about concrete, penetrable concrete. Is that an option that you all considered for the parking lot, or?
We really didn't consider it because we certainly could if you wanted us to. But we have touched base with Public Works, and they are okay with this.
Well, you're certainly to be commended for all the work you've done to meet with the community and the changes you've made in plans in order to accommodate some of the community's preferences.
I agree, and so unless there are any other questions, I'm going to close the public hearing. Okay, public hearing is closed. Discussion? Tell you what, I'm going to go ahead and make a motion that I move the board approve the special exception use permit because the board finds that all of the requirements of MCL 17.16.150 have been met. And in addition, I'm going to we make a motion that the board, well, it's all the same motion, but anyway, that the variance be granted because all of the requirements of MCL 17.40.370 have been met. The board finds that the unique characteristics of the property are the unusual shape of the lot and the special needs parking for a church which swells during certain times of the week and not in other times.
I'll second that motion.
Got a motion, got a second. All in favor? Any opposed? Passes.
Thank you.
Mr. Chairman, the Board of Zoning Appeals is adjourned. Thank you.
Hot diggity.